She's so fine. Helluva blows my mind. Helluva lights my day.
What's good, guys? Today is Monday, November the 7th, 2022. This video is going to be picking up where we left off in the last video, which is covering the initial complaint filed in the Kenneka Jenkins case. And I believe I was on number 24, so we're just going to pick right back up there. Number 24. After last being seen leaving a room on the 9th floor, plaintiff's decedent, Kenneka Jenkins, was visibly disoriented and in dire need of assistance. Crown Plaza defendants, through their employees and/or agents of defendant Capital Security, should have assisted plaintiff's decedent Kenneka Jenkins, which would have prevented her death. What that's saying is, after Kenneka was seen leaving the room on the 9th floor and being in obvious disarray, in obvious need of assistance, Crown Plaza and Capital Security, through their employees, should have stepped in and done something with Kenneka Jenkins, which would have prevented her death. Very simple there. Number 25. Upon information and belief, there's that wording again. Crown Plaza defendants maintained several double walk-in freezers within the hotel, but locked and sequestered them from access by the general public. Now, if you missed it in the last video, this upon information and belief statement is upon information obtained from Miss Teresa's attorneys, or Miss Tereasa, or upon research that they've done and their belief in that research. They believed that the Crown Plaza had several double walk-in freezers that were in that hotel but were locked and sequestered from access by anybody else in the general public. All right. Number 26. At all times relevant here too, the kitchen within the Crown Plaza Defendants Hotel contained a double walk-in freezer that was accessible to the general public and all defendants' agents and or employees without restriction on access. All right. So at all times relevant to this complaint, the kitchen at the Crown Plaza had the double walk-in freezer, and the general public and anyone else had access to it without restriction. Anybody could have walked in off the street and had access to that freezer. Number 27. At all times relevant here too, the double walk-in freezer in the abandoned kitchen within the Crown Plaza Defendants Hotel had a sticker affixed that was completely faded and failed to instruct how to release the lock system of the door. Now, what they're saying here is that all times relevant to this specific situation, the walk-in cooler / freezer had a sticker that was affixed, but it was so faded that you couldn't have seen how to operate it. Number 28. At all times relevant here too, the double walk-in cooler in the abandoned kitchen of the Crown Plaza Defendants Hotel was unused and did not contain any food or produce. I think that's pretty self-explanatory. They weren't used in the freezer, and it didn't have any food or produce located inside. 29. Upon information and belief, all coolers and freezers within the Crown Plaza Defendants Hotel were supposed to be temperature monitored on a regular basis. I think that too is self-explanatory, even though they are saying, upon the information they received, the research they did, and the belief in those things, the Crowne Plaza was supposed to keep the freezers temperature monitored on a regular basis. Number 30. On or about September the 9th, 2017, at approximately 12:36 p.m., plaintiff's decedent Kenneka Jenkins was reported missing to the Rosemont Public Safety Police when the family did not receive a response from the Crowne Plaza defendant's hotel staff and employees and or agents of defendant Capital Security. Now what that's saying is that on or about September the 9th, 2017, at approximately 12:36 p.m. in the afternoon, Kenneka Jenkins was reported missing to the Rosemont Public Safety Department when the family didn't get a response from the hotel or Capital Security. Number 31. On or about September the 9th, 2017, at approximately 3:20 p.m., the Rosemont Public Safety Police commenced an investigation at the Crowne Plaza defendant's hotel. Pretty easy there. On September the 9th, at roughly 3:20 in the afternoon, the Rosemont Police Department began an investigation at the hotel. Number 32. Upon information and belief, it was not until after Rosemont Public Safety Police requested review of the surveillance that the Crowne Plaza defendant's staff and employees and or agents of Capital Security actually began the undertaking of reviewing surveillance footage. Upon information received by the plaintiffs and the plaintiffs and her legal team, and the research that they did, and the belief in both of those things, it was not until after the Rosemont Police Department requested a review of that surveillance footage that the Crowne Plaza staff, employees, as well as Capital Security actually began reviewing their surveillance. Number 33. On or about September the 9th, 2017, at approximately 10:30 p.m., an unidentified employee entered the aforesaid kitchen and failed to discover plaintiff's decedent Kenneka Jenkins. Also cut and dry there. September the 9th, 10:30 at night, an unidentified employee went into that kitchen and did not discover Kenneka Jenkins. Number 34. On or about September the 10th, 2017, at approximately 12:25 a.m., plaintiff's decedent Kenneka Jenkins was found unresponsive inside of the double walk-in freezer of the aforesaid kitchen of the Crowne Plaza defendant's hotel. On September the 10th, shortly after midnight, Kenneka Jenkins was found unresponsive inside of the freezer, inside of the kitchen, inside of the Crowne Plaza Hotel. Number 35. On information and belief, decedent Kenneka Jenkins was caused to die from hypothermia and or freezing to death, which caused immeasurable conscious pain and suffering prior to her death. So upon information that the plaintiff and or her legal team received, research, and the belief in both of those things, Kenneka died from hypothermia and or freezing to death, which caused her immeasurable pain and suffering prior to her death. And the information that they would have gotten would have been from the medical examiner's office, That would have been their main source of information in regards to that. Now, it goes into counts. Count 1, negligence, gross negligence, premises liability, Crown Plaza defendants. Number 36, plaintiff's decedent re-alleges and reasserts all previously enumerated paragraphs as though fully set forth herein. So everything that we've read so far is what they are, Ms. Tereasa and her legal team are alleging. Number 37, at all pertinent times herein, Crown Plaza defendants owed a duty to provide security and maintain a safe premises. That's just cut and dry. When you are staying in a hotel, it is the hotel's duty to keep you reasonably safe while on their premises. Number 38, at all pertinent times relevant herein, Crown Plaza defendants owed a duty to warn of or otherwise take reasonable steps to protect the general public, its business invitees, guests, and plaintiff's decedent Kenneka Jenkins in particular, regarding the state of the premises or acts done or omitted on them. So at all times relevant here, the Crown Plaza owed a duty to all the general public, any kind of person who was invited there for business or pleasure, guests, and specifically Kenneka Jenkins, to warn them or take reasonable steps to protect them while on their premises and protect them from acts done or omitted on their premises. 39. At all times relevant hereto, Crown Plaza defendants owed a duty to warn their agents and or employees of unreasonable risks and dangers on their premises. And what they're saying there is that Crown Plaza had a duty to tell their employees and people acting on their behalf about unreasonable risks and dangers on their property. Number 40. At all pertinent times herein, Crown Plaza defendants owed a duty to the general public, its business invitees, guests, and plaintiff's decedent Kenneka Jenkins in particular. And then it says maintain a safe premises. So they've left out a word here. But what they're saying is, at all times relevant, the Crown Plaza had a duty to inform the general public, anyone they had on their property as a guest, anyone that they invited there as far as business went, and specifically Kenneka Jenkins, that they had a safe, that they were maintaining a safe premises. 41. At all pertinent times relevant herein, Crown Plaza defendants owed a duty to the general public, its business invitees, guests, and plaintiff's decedent Kenneka Jenkins in particular, to warn of latent defects or dangers, such as abandoned kitchens and or accessible double walk-in freezers. So in this paragraph, they got it even more specific and said that at all times relevant to this lawsuit, that the Crown Plaza, the hotel, had a duty to the general public, any business person they invited on their property, any guests, and specifically Kenneka Jenkins, to warn them of any kind of defectiveness or dangerous things, such as specifically an abandoned kitchen and or an accessible walk-in freezer, double walk-in freezer specifically. Number 42. At all times relevant herein, or at all times relevant, rather, defendants owed their business invitees, guests, and plaintiffs decedent Kenneka Jenkins in particular, a duty to exercise a reasonable care to ensure that services undertaken by security services and food service providers were done so in a manner so as not to inflict injury upon others. What they're saying there is that the hotel had a reasonable duty to their guests, to anyone they invited there for business, and specifically Kenneka Jenkins, to ensure them that the services provided by their food service workers and by their security services, were done so in a manner not to inflict injury upon anyone else. Number 43. At all times relevant, Crown Plaza defendants owed a duty to the general public, its business invitees, guests, and plaintiff's decedent, Kenneka Jenkins in particular, to properly supervise, train, and hire its personnel who were working at the Crown Plaza defendants hotel. That's pretty cut and dry as well. The Crown Plaza had a duty to the general public, anyone they invited there for business, and specifically Kenneka Jenkins, to properly train, supervise, and hire. They went so far as even to say hire personnel to properly take care of their business there at the hotel. Number 44. At all times relevant hereto, Crown Plaza defendants owed a duty to their business invitees, guests, and plaintiff's decedent Kenneka Jenkins in particular, to maintain policies and or procedures so as to prevent injury upon others when undertaking a duty to act. What they're saying here is that the Crown Plaza had a duty to anyone they invited on their property for business, a guest, and specifically Kenneka Jenkins, to maintain their policy and procedure manual so as to prevent injury to other people when undertaking a duty to act. 45. At all pertinent times relevant hereto, Crown Plaza defendants owed a duty to the general public, its business invitees, guests, and plaintiff's decedent Kenneka Jenkins in particular, to provide adequate security for their hotel, to protect the premises and their patrons. What that's saying is at all times relevant here, the hotel had a duty to the public, anyone they invited there for business, and guests, and specifically Kenneka Jenkins, to provide adequate security for their hotel, protecting their property and their patrons. That's their duty to do that. Number 46. This is where it gets into the nuts and bolts of it. That Crown Plaza defendants were negligent and or grossly negligent and responsible for. And they have listed things. We're going to go over these. Failing to secure areas which should have been closed off to the general public. Failing to secure areas is restricted to employees only. Failing to maintain proper signage. Failing to warn of a dangerous condition. Maintaining a defective and faulty freezer. Improperly allowing a dangerously designed freezer area to remain in operation, unsupervised and open to the public. Make these a little bit bigger. Failing to maintain the latch and entry system to their kitchen freezer. Failing to secure an area otherwise inherently dangerous. Failing to timely review security cameras when undertaking a duty to do so. Failing to hire, manage, supervise, and train employees and or agents who were competent to deal with missing persons in a reasonable manner. Failing to hire, manage, supervise, and train employees and or agents who were properly trained not to negligently disregard dangers to the general public. Failing to hire, manage, supervise, and train employees and or agents who were competent. Failing to hire security providers who are competent and capable of acting reasonably under the circumstances. Failing to hire food service providers who are competent and capable of acting reasonably under the circumstances. Failing to enforce existing policies and procedures to prevent the conduct described herein, and or failing to promulgate sufficient policies to prevent the occurrence alleged herein. Failing to adopt proper procedures for their employees and personnel, and failing to properly and adequately train its staff with relation to safety procedures of personnel-only areas. Now, that was a mouthful. So what they're alleging here is that, and I'm sorry, this is a PDF document, so that's going to keep popping up over on the side. But Miss Tereasa and her legal team are saying that the Crown Plaza failed to secure the area, which should have been closed off, failed to restrict areas that were for employees only, didn't have proper signage up, failed to warn of a dangerous condition, such as the kitchen area where they were doing the construction, that they had a defective and faulty freezer and they kept it, improperly allowing this dangerously designed freezer, as they worded it, area, to remain in operation, unsupervised, and open to the public. They talk about the latch and entry system to the kitchen freezer, that they failed to secure the area, even though it was dangerous, failed to timely look at those security cameras when they had an undertaking, when they had a duty to do so. That was their duty to look at those security cameras, and they failed to timely do that. They didn't hire, manage, or supervise employees who were competent to deal with the missing persons. Well, that's clear. They failed to hire, manage, supervise, and train employees who were properly trained in regards to dangers to the general public. Failed to hire, manage, supervise, and train employees who were competent. They took it a step further. They failed to hire security who were competent and capable of acting under these circumstances because they didn't have a clue. They failed to hire food service providers who were competent and capable under these circumstances. They failed to enforce their policy and procedures to prevent all of this from happening. They failed to adopt proper procedures for their employees and the personnel. And they failed to properly and adequately train its staff with safety procedures. That's what led to all of this chaos in the hotel. Nobody had the sense God gave them. Nobody. So I'm going to end it here, and we're going to pick back up at number 47, and we are going to get through this. But I think it's important. I still think it's important for you guys to understand what it is that Miss Tereasa is asking for by and through her legal counsel, so that you can then understand, once the lawsuit has reached its end, whether she got what she was asking for. All right? It's important to know what she wants. So I'm going to end the video on that note, but thanks for watching, guys.